my right is Gürkaynak, who is a high-power lawyer in Istanbul, in Turkey, specialized in international property as well as competition. Let me turn to Gürkaynak now to your lawyer. You operate in Turkey, but also internationally. What is your take on the way the courts and the competition authorities have been behaving, and what do you see as the limitation of the scope for enlarging their perspective on, and probably particularly on mergers, because this is the most crucial issue that we face in the digital sector?
Thank you. Thank you. I work indeed quite a bit, also academically, on innovation theories of harm in the merger control context. As you said, I do work on technology-intensive markets as an attorney as well, quite a bit. I can say that I have reviewed all of the cases in the EU and in the UK and in the US quite closely and carefully for a recent work that I am doing at the academic side, where they contain any element of innovation, any element of innovation theory of harm. And one particular finding that I have about all of that is that something that we so easily agree on is not that apparent in those decisions. And what we agree on so easily is that there is no bright line rule, and there has to be a case-specific, case-by-case analysis of the economic assumptions, and there should be no economic assumptions or legal assumptions. Basically, when you read these cases, there is a prevailing factor of mergers will lead to a reduction of innovation, almost an assumption that a concern is about to loom, and is there a redeeming virtue of this merger anyway? Whereas the way it should be, and this is how it should be structured, I think, is if we were to understand that mergers are not an optional privilege or a luxury in the sphere of innovation, but they may, in certain cases, be necessary for innovation, then it's not going to be that simple to just have the transaction parties work against assumptions, and particularly Arrowian presumptions. I am suggesting that one of the barriers is, while there is the talk of, yes, Arrow and Schumpeter, and there are two camps, there is quite a bit of deference to Arrowian predictions when it comes to merger control. Yet those Arrowian predictions need to be a point of proof in each case as well. Does it really apply to this case? And that question is not sufficiently asked. So we're basically looking at a lot of cases that are reducing innovation considerations to a supportive role of unilateral effects concerns. Whenever the antitrust authorities have unilateral effects concerns, suddenly they're giving a supportive role to innovation considerations as well. I'm not saying all of the innovation theory of harm cases necessarily have a unilateral effects concern angle to it, but there's too much of a mush of these two, and it almost looks like paying lip service to innovation theories of harm and just bringing a supportive role in that fashion. We're looking at a very quick shift in burden of proof as well. It shifts to the merging parties very quickly, and those parties do not have holistic data on the entirety of the market. Unfortunately, the exercise that needs to be done in the innovation theory of harm kind of an exercise is a holistic exercise that has to capture the entirety of the market, and comes in the very accurate question by Jenny, which is, do we even know the boundaries of the market anyway? So when you don't know the boundaries of the market, And you're not even looking at the entirety of the market because you're too quick to shift the burden of proof on the parties. So the parties are basically making do with the data available to those two parties as transaction parties. That's already giving a suboptimal result. So what should we do? We should look into the market characteristics and the market structure holistically. We should not give a very weak role to synergies. I think synergies, particularly in merge control context, is not getting enough gravitas in the sense that it's not calculable, it's not very articulable, so suddenly it gets defeated by the competition authorities very quickly based on it not being calculable. Whereas actually synergies, i.e. the complementarity and the scale and the growth, is an important aspect of the innovation incentive as such. So if you're going to discuss innovation incentive, you need to be discussing the synergies as well. And key innovation drivers will need to be looked into. And in my last two sentences of what needs to be done, I would say, and again, complementary to Thibault and James particularly, I would say process innovation is not getting much attention either. It's always product innovation that the authorities are focusing on. So by way of saying that, I'm also saying it's always short-term and not mid to long-term. But process innovation is almost non-existent in any of these decisions. I couldn't find any decision that is looking into the potential process innovation. I understand why that happens, because it looks speculative to the authority, but we have to call a spade and say that a lot of the theories of harm of the authorities are very speculative as well. So if these can be used as sword, they should be used as shield as well. So solution is, I think, in knowing what we do not know. In these packages that Concurrences is distributing outside, there's this book, the Concurrence Competition Law Review. In there, I have an article published in December 2022 called An Evaluation of GAFAM's Acquisition Proposals in Light of Experimental Studies. Basically, that academic article is concentrating on what we do not know. And it says we don't have enough to suspect that when it is GAFAM that is doing the acquisition, suddenly there is perils of acquisitions. It doesn't suggest that we should be lenient, but it says we should have no presumptions. So if I were to very quickly go over what should the antitrust agencies do very concretely. One, there should be a neutral starting point of analysis. We should neither be Arrowian nor should we be Schumpeterian. There should be a neutral starting point. So I'm following the lead of Katz, Shalansky, Julian Lefuli, De Nicolo, and Polo in their approach of how to do the analysis in innovation intensive markets. There should be no quick shift of burden of proof, and the Arrowian predictions should be subject to test as well. There should be a complex case-specific balancing analysis with a counterfactual analysis being what would have happened if this transaction didn't go through and these sorts of transactions didn't go through. What is the track record of mergers and what are their impacts on innovation in this specific market? There has to be a holistic review of the entire market with its parameters. Internal correspondences, in my view, are relied on too heavily at the moment, and they should be corroborative evidence, but internal correspondences in the innovation sphere should not be dispositive evidence. There should be equal footing in standards of proof of concerns and dynamic efficiencies if a particular set of standards of proof is being used for the articulation of concerns in the field of innovation theories of harm, then dynamic efficiencies should be subject to the same standard of proof and shouldn't be higher. When the authority uses general economic literature to show concerns, they should not be able to say this is just general economic literature when dynamic efficiencies are being put forward through that means. And there should be no dispositive reliance on general economic literature either. I'm talking about the type of demonstration of that act in Annex 4 of the Dow-DuPont case, for example. There should be some focus on process innovation and cost efficiencies in innovation. No one ever goes into the matter of cost efficiencies in the act of innovation, except for one decision that looks into it. And the earlier the stage of innovation is, the higher the standard of proof should be. We're not discussing this enough, in my view. So suddenly discovery phases are also a cause of concern since since Deutsche Börse basically. And we are not applying a different standard of proof of concerns, whereas when this innovation is going to hit the market, should be controlling on the level of standard of proof for the agency. So articulation of worries should be more difficult if it is earlier stages. And the last thing is the authorities should accept to engage in complex remedy discussions when it is innovation issues. In the merger control sphere, a serious problem that I believe exists right now is, while articulating the innovation worries, the authorities are very innovative in their own way, and they break new ground and they're coming up with complex analysis. But the minute the ball game is addressing those concerns, they are resorting to memorized patterns of how these kinds of concerns should be addressed. And they never use a new measure beyond the traditional measures. In fact, we see specific language that says this is too complex, this is too complicated. Well, it is going to be too complicated because the theory that you use for the innovation theory of harm is also very complex and complicated. So if I were to address only the unilateral effect side of things and be done with it, then we're just giving a supportive role to innovation theory of harm, which should not be the case.
I have a question of whether there's sufficient coherence in how regulators see the competition space in digital services. And by that I mean, when we talk about the competition service by service or product by product, and all the emphasis is, how difficult it is. And then when we talk about mergers, suddenly it's almost like everybody could be a potential player. And so is there any attempt to find a systematic mapping of what, and I'm probably introducing a bit to the next panel, but on the innovation issue, is there an attempt to start thinking, who is a player we would want to look at, and who is a player we may not want to look at in a particular market?
So, in terms of player, I also read it as agencies that are enforcing, right? If that is also an angle of the question, you're allowing us to make a point that maybe we should have made, one of us, which is that it's also fascinating to see how much of a divergence there is in the recent decisions in terms of what is still a lingering concern of Microsoft Activision. Two authorities that are right next to each other. Yes, okay, there has been Brexit, but these markets cannot be that different. They're not moving in silos, especially in a sphere of concern like innovation. And one agency says this is enough to address the concerns. The other agency says this is not enough. Or with Meta Giphy, or with very many other examples, we're seeing very closely situated agencies coming up with very different decisions, which also, I think, should be a flag that divergence is not in and of itself a bad thing, but it should be a flag that someone is getting it wrong. And do we have the luxury of getting it wrong in the innovation sphere? Because that's the biggest engine of economic growth and welfare maximization. So that is, I think, a good point.